Someone make it make sense.
Probably a couple.
Our jury, good morning.
All right, here we are, guys.
Confirm before we start this morning that you complied with the court's instructions last night to not have any conversations amongst yourselves or anyone else about the persons, places, things, or charge involved in this case. Then you have not conducted any independent investigation regarding those items. You just raise your hands to confer that you complied with the court's instructions. All right, the record will reflect that all jurors have raised their hands. Members of the jury, yesterday, I told you that you may happen to see the lawyers in the courtroom or in the courthouse going about their affairs. And again, they're not trying to avoid you or speak to you because they're not allowed to. Did anyone happen to ride an elevator this morning with any of the attorneys, either for the state or for the defense? All right, juror in seat number 3 from my left, first row. Yes, ma'am. Okay, thank you. Can you all approach for a moment?
Okay, so while they're approaching, I'll just let everybody know. They had
and a juror in seat 4, left to right, first row. Yes, sir. Who did you ride the elevator with? Do you recall who specifically, sir? Mr. Owens. Okay, thank you.
Okay, so they were delayed getting started. Obviously, we are live with the court feed here, but they were delayed getting started. They had that Richardson hearing over the discovery, and there was a further discussion about what exhibits can or cannot be used in opening statements. Up until about 5 minutes ago, there was much debate over a picture of Sarah sitting on her porch with the dogs. And every time Judge Kranik said, okay, can we bring in the jury? Mr. Owens raised another issue he needed to take up. And so they
I thank you both for your honesty. I appreciate that. Something we talked about earlier this week. That's the one thing that we required and asked of you is just be open and honest. And I appreciate both of y'all's open and honesty. During the ride in the elevator, was there anything that you saw or observed that it would impacted you or influenced you in any way to have any impact on you? Juror number 3, left to right, first row. Juror number 4, left to right, first row. Okay, thank you. All right, with that,
let's go.
Members of the jury, we're going to proceed with opening statements. Both the state and the defense will have the opportunity to present them. I ask that you listen closely to those statements that they're going to provide. But remember, these are not evidence. This is just the party's belief as to what the facts and the evidence will show in this case. After the conclusion of the opening statements, we'll begin with the state's case in chief through witnesses. With that, Mr. J, you may proceed, sir.
Here we go.
Ladies and gentlemen, what the evidence in this case is going to show you is that this defendant zipped Jorge shot in a suitcase. She was able to do this because at the time of his death,
why do they not have a lapel mic?
103 pounds.
God.
She did this with the malicious intent to punish him, and then she went up to sleep and left him to take his final breaths on this earth alone. How many breaths those were, we don't know. The evidence is going to show that it was at least for about 15 minutes, because there's going to be 2 videos that the defendant herself took of this event. The evidence is going to show George Torres is dead because in this defendant's judgment, he deserved it. Now, have a conscious disregard for whether he lived or died. You will see and hear these videos. What I expect you will hear from a video that began at 11:12 p.m.
Thank God.
45 seconds on February 23rd, 2020 in Orange County, Florida, is a suitcase on the ground face down.
There it is. First counter.
Zippers facing the floor. You will hear Sarah, the defendant will say, "For everything you've done to me." Sarah, "For everything you've done to me." Sarah, "Fuck you." And then the defendant laughs. Sarah, fuck you. And the defendant laughs. Sarah, stupid. Sarah, that's my name. Don't wear it out. Sarah, I can't fucking breathe, baby. Seriously. Yeah, that's what you do when you choke me. Sarah. 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 The defendant laughs again. Sarah, I can't breathe, babe. She laughs again. That's on you. Sarah, I can't breathe. She laughs again. Unintelligible words. And I would submit the evidence is going to show, because of the intoxication from alcohol, is the next thing she says. Sarah, 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 I can't breathe, baby. That's what I feel like when you cheat on me. Sarah, fuck you. I can't fucking breathe, Sarah. You should probably shut the fuck up. Sarah, shh, is the last thing you will hear the defendant say to Mr. Torres as he is face down, zipped shut in a suitcase. That, again, began at 11:12:45 and lasts just over 2 minutes. At 11:23 and 3 seconds p.m., there's a second 22-second video, and it's the defendant zooming in on the suitcase. And all you hear during this 22 seconds, after he's been in this suitcase since at least 11:12 p.m., is one more time, Sarah. How did we get to this point where 103-pound George Torres is put into this suitcase left to die? Well, the next morning, the defendant wakes up, late morning, perhaps early afternoon, somewhere in this time range, several hours later. And she goes downstairs, and she doesn't see George anywhere. Torres.
Go back to the microphone. Heard it again.
The first thing she does after taking him out, and I believe you will hear a description by the defendant saying, took his little legs out. At some point she makes that statement. And tries to resuscitate him. Here's gurgling as she presses down on his 103-pound chest, forcing whatever air was trapped in there out, gurgling. Then the next thing she does is she doesn't call 911. She calls Brian Boone. Brian Boone. Brian Boone.
Do y'all see the suitcase over there? The big box?
The sheriff's child in common.
Crazy because it's so small, right?
And this date, February 24th.
Amazing he was even able to put it in it.
Monday. A normal work day for most people. School day for their child that they share in common.
Sure wish you would go back to the microphone.
But after they got divorced, the arrangement was every other weekend, no co-parent.
I'm going to see if I've got subtitles I can put on that would be able to help since he's away from the microphone.
Tuesdays, their child would be her responsibility. Wednesdays and Thursdays, their child would be Boone's responsibility. So February 23rd, 2020 was a Sunday. Now he's led into Monday. Mr. Boone had been trying actually to contact the defendant several times that morning because he just wanted to confirm she was going to get their child after school that day. And there had been a history of reliability issues on that issue on her part. So you will see in the phone record, he calls her. Then she finally calls him back instead of calling 911. And being the nice co-parent that he is,
Coconut ideas.
over.
think the coconut idea was playing hide and go seek with a suitcase.
Which allows you a view all the way to the back sliding glass door. You're going to see that our kitchen is off to the right. There's a doorway that you see all the way through. And on the back side of the kitchen in the breakfast room area, there's tables and stuff. There's also some blue legs sticking out in view. Brian Boone says, check please. You need to call 911. He doesn't set foot into that townhouse. He does wait outside though.
So
now, after having first called her ex-husband,
I'm going to pause it really quick. So I hate that it's hard to hear because he's away from the microphone. That's why I have subtitles on. But I wanted to point out, it sounds like he's saying that there were legs sticking out of the suitcase. So I don't remember hearing that before. That might be brand new information that would show that she was maybe trying to, when she woke up or whatever, maybe was trying to get him out of the suitcase. But that's what he said, that her ex-husband saw legs sticking out. So I just wanted to point that out because I think that's new information.
after having first waited for Brian Boone to come over, the defendant
Makes the 911 call.
What you will not hear
Thank God.
are tears. What you will not hear is sorrow.
Can you hear tears?
You hear a certain level of concern.
Can you hear tears? Here we go. Hide
My
and seek.
boyfriend and I were playing last night. Put him in a suitcase, and we were playing hide and seek kind of thing.
Yeah.
I fell asleep. Found him dead in the suitcase this morning. I don't know what happened. He had blood coming out of his mouth. Don't know if it was an aneurysm. Pulled him out of the suitcase, tried to give him CPR.
Okay.
He was in the suitcase and I fell asleep. He's not awake. He's purple. He's not breathing. There's some instructions about how to do CPR given to her, asking about whether an AED is available to shock his heart. It's too late. He's cold, he's stiff, he's purple. We were playing hide and seek. We were playing hide and seek. This is horrible. This is horrific what happened. Like, what happened? We were playing hide and seek last night and I fell asleep. So she mentions that there was blood coming out of his mouth.
Mm-hmm.
And his body, like all bodies in his death, was taken to the ninth division medical examiner's office in autopsy. What the doctor found was what you would expect after being left in the suitcase, crumpled up in the fetal position. He passed from positional asphyxiation, meaning like you're not going to get full breath.
Positional asphyxiation.
And environmental suffocation. You don't have to have a plastic bag over your head, tape shut with a full roll of duct tape to seal it off 100%, be worthy of the vacuum of space to environmentally suffocate. It's close enough if you can't get the oxygen and the CO2 coming in and out of your environment. But she also did notice, suffered from blunt force trauma on his torso, in his face, his mouth. She'll use words like contusion.
Okay. I'm gonna pause again real quick. He's so quiet because he's away from the microphone that even the subtitles can't always catch everything. So right now what he's explaining is he's explaining to the jury positional asphyxiation, which anyone familiar with this case probably is already kind of aware of. But basically that, because of his position in the suitcase, that's how he died. But that also what he's getting into now is that the medical examiner found that he had been hit and there was blunt force trauma. So what I'm going to do is when he's really quiet and there's no subtitles or the subtitles are wrong, but I can kind of hear what he's saying, I will try to, say what he's saying. So hopefully that helps. I'm sorry that he's so hard to hear.
She'll use words like hematomas. Will help her understand for you all that means bleeding under the skin and blood. But you expect to improve. That's why they're running kids. But he had all this additional trauma. He had trauma on his fingers as well.
He had additional trauma on his fingers.
Now, Sheriff's Office, Orange County Fire Rescue show up. And the defendant interacts with the first patrol officer. You will see and hear that body-worn camera. few hours later, the detectives from the homicide unit at Orange County Sheriff's Office approach her and are ready to interview her after doing some initial things, which includes grabbing her cell phone off of the counter that was found by the suitcase and those records, and giving it to one of their digital forensic examiners, who we'll hear from later in the trial. But it's time to give the first interview with the defendant. So they do a first interview with the defendant in one of their unmarked detective patrol cars there on the scene. And the basics of this remain the same, but there's a little more elaboration, as you would expect from trained detectives versus getting the 911 call taken. But the basics of what the defendant tells them is we had wine, we painted, we drew, we did puzzles. The particular wine we had was a Chardonnay from the Woodbridge winery. The bottles, plural, are in the trash. We started about 4 p.m. after Mr. Torres went to the store. Puzzles, art, listening to music, enjoying each other's company. We were literally just enjoying one another's company. The other bottle of wine that was left over from Boer wasn't even half full. So the description she is saying is 1 bottle of wine and plus a fraction of a bottle of wine left over from the night before. Ladies and gentlemen, not all bottles of wine are made the same. Many of us may envision what you would expect at a restaurant. Those are 750s.
He's going to say it's a big, giant.
Bottles of wine that were recovered from the defendant's trash can were 1.5 liters. So the equivalent of 2 standard
Jumbo
bottles of wine. A 1.5 liter bottle of wine is 50 ounces. Given that a standard serving of wine is 5 ounces, you can begin to do the math. And there's receipts. The day before, Saturday, February 22nd, 2020, there is a receipt from Publix for a bottle of Woodbridge wine for $9.74. And then Sunday at 12:17 p.m., there is another receipt for $9.74 for a Woodbridge Chardonnay bottle of wine. And then at about 5:30 in the afternoon on February 23rd, again, there is another receipt for the same bottle of wine,
Wow.
the same price.
Wow.
And those 2 bottles of wine were recovered. They're going to be produced to you in evidence, and you will see that they are, in fact, Magnum bottles of wine.
Magnum. Shout out.
So that's the context that we're dealing with when we hear things like, we only had 1 bottle of wine, and we finished what was left in the bottle of wine from before. Well, ladies and gentlemen, there's 2 1.5 liters that apparently were consumed by a 103-pound man and the defendant, who is in the same weight class. Plus, if you believe that the defendant and the decedent would leave leftover wine from any given day, any additional wine that was remaining from the 1.5 liters from Saturday. Ladies and gentlemen, that's a lot of wine. So in that context, we were just having wine, enjoying each other's company. At one point, we play hide and seek. She says she didn't zip it up all the way. There was enough room, in her words again, there was enough room for his little fingers to get out. We were still having a good time and whatever. And basically, Mr. Torres is stressing out about jobs, his ex-wife, about money. And so they're just doing puzzles and doing things to keep his mind off of it. Doing art, playing with the dogs, dancing with the dogs.
Cute.
Playing hide and seek. We were always trying to outdo each other where we could find each other the best.
Yeah, but he needed, dude.
When they started playing hide and seek, she went up to the shower and then got tired of hanging out in the shower and came down. And that's when she found him playing around in the suitcase. We both thought it was funny. I'm going to zip you up.
Right. That's why it's not hide and seek, people.
2 little fingers could stick out. And she went upstairs thinking, he'll get out. We're going to have sex and go to sleep and call it a day. It was a good day. She insists that they had wine, but were not drunk. You will be able to assess
Mens rea.
that for yourselves when you hear the recording she made. No ill will between us last night. Last argument, maybe last week. Don't really argue. We came home, drink, smoke, did art, listen to music, play with the dogs. We drink what we can afford. We used to be able to afford liquor, but now we can only afford wine.
Wine's way more expensive.
And that's how that day ends with the police. She goes and sleeps and stays at her ex-husband's house the night of February 24th. What they are doing, and by they I mean the Orange County Sheriff's Office, in part,
So she stays. Interesting.
that's when they discovered the.
So I don't think I knew that one. So she stayed at Brian Boone, her ex-husband's house, while they were, conducting their investigation. She stayed there for 2 nights, it sounds like. So it's going to be great when we get to hear him testify, because he's going to have a lot of information, knowing how she talks, right? And she stayed there for 2 nights.
2 videos that I just described for you. And there's other things in the phone, which I will discuss with you in a little bit. But she's summoned in for another interview, and she sits down and gives another interview on February 25th, now Tuesday. She does describe past instances of violence. You're going to hear about that. She's going to say,
Suitcase in a box.
Mr. Torres had hit her with a curtain rod about a month ago. Since then, though, we've been good. I've been good.
I've been good. She says it like that. I've been
She
good.
describes that he comes at her all the time. He comes at me. So it's either I flee or I try to go upstairs and go to sleep. That's usually what it is. I don't know if you talk to Brian, her husband, about any of that, but most of the time I flee and I go over there. There's a discussion about why she stays with him, and you'll hear that for yourself. She will say that she doesn't really want to drink. She just takes an occasional drink. She drinks to placate him, Mr. Torres. She says that you're going to see phone videos of Mr. Torres smashing her TV in the past, like a month earlier. You may see that too. But she doesn't get drunk. When she drinks, she likes being non-compos mentis, her words, not mine, having her wits about herself. Then she gets to the hide and seek again and describes that they've played it 3 times before, but had never zipped one another shut in it before. And they were really just running out of places to hide because it's just a townhome. She does not remember, according to her, she does not remember taking any photos or videos of the night's events.
Oh boy. Oh boy.
At this point, they
Should've
ask her, well, would you like to see it? And she says, I can't watch this. I flipped him over. I flipped him over, and that's where it was. Guys, this is killing me right now. That's why I flipped it over between the 2 videos. I didn't do anything intentional. Discussion over whether he had enough room to get any of his fingers out from the zipper. My intention was not to leave him there. We both got in there. Both of us were in there. When she went upstairs, my plan was not to, quote, he'll be up here any minute. My plan wasn't to leave him in the suitcase. Why is all this going on? It's the drinking. That's what it is. It's the drinking. I thought he was okay. Guys, that's how we were with each other. Nobody understands our relationship. This whole suitcase thing never happened before. Though she described it happening before. I'll never drink alcohol again.
It's so interesting. It's like she said, she thinks that this is the problem a lot of people have with these interrogations, right? They think that by explaining what they did or what they think happened, that the law enforcement is just like, oh, okay, you're right. Yeah, you didn't do anything wrong. And then here she's almost trying to bargain with them, right? I'm going to quit drinking. I'll never drink again, as if she thinks that they're just going to let her go, which is really crazy, right?
She insists that she has no injuries on her. And you don't have to take her word for it, because they took photographs of her and there were no injuries on her. She insists over and over that there was no violence that day. It's like, okay, we're in a good place right now. Ask her about saying fuck you to Mr. Torres. Well, that's just being playful and having a good day. Everybody's having a good day. I didn't touch him, nor did he touch me. Her words.
That's not good for their defense.
What else is found on her phone? There's a conversation between Mr. Torres's brother, and again, nobody knows who's using these phones at the time text messages are sent in these records that you're going to see. But it's indicated that there's a communication between one of the decedent's brothers and the owner of the phone that was taken that belongs to Miss Boone. The text from the brother is, yo, my daughter told me what you did, Sarah. I don't want you around any of my daughters or nieces, nephews. And that's Christmas 2019, just under 2 months before this event. She replies, or the person using her device at this time, ugh, your quote unquote dad hit me in the face. The next text is, hide and seek, I shall.
What does that mean?
January 13th, there's another heated discussion. She describes it on January 13th in a text to Mo, the brother again. It's a Torres thing. Boo. Sends a picture. Keep the fugly creep out too. It's still fugly. Lose. The brother responds, please do something with yourself, Sarah. God bless you. The defendant's response, and bless you and all of you too. I'll get, in all capitals, rid of him. Then it'll be, in all capitals, better. Ugh, Torres. Referring to Mr. Torres, getting rid of. And that's the case. That's what the evidence is going to show. But we, the state of Florida, and the members of the jury in our journey through this case, we're all going to come up to a door that says, danger, keep out, stay away, by court order. And that door says, the defendant's history with the victim is a door we shall not enter without permission and invitation. Halloween in like 13 days. Part of the vampire lore is vampires can't come get you in your house. Well, I participate during this trial. We're going to be invited in to the defendant's past relationship for the previous couple of years. And as we come inside this room, at her beckoning, we are going to have things pointed out that she would like us to focus on. And you're going to hear the first night the defendant met the decedent, Mr. Torres, he smashes her phone, punches her. It's the first time in her life she'd ever been punched. I expect that's going to be. And he made her curl up in a fetal position on her own porch for 4 hours, and she was only able to escape this situation when he fell asleep. I expect that you're going to hear that Mr. Torres is an alcoholic. I expect you may hear his high score on his blood alcohol level.
So what he's doing right now, I know it's impossible to hear him right now. What he's doing is this is actually really smart. He's laying out all of the evidence that he is expecting to hear from the defense that would paint, George Torres in a negative light, right? You're going to hear that he hit her here and there. You're going to hear about his blood alcohol level. And so what I would expect is after he lays out all of this evidence, he's going to explain to the jury why it doesn't change anything in terms of her culpability. But let's see what happens.
This is a man who had serious alcohol problems, and I expect you're going to hear about that. Despite that first date, and this is going to tie into some other things that I expect could possibly come in. Despite that first date, despite at that point in time of this first date not having a relationship, emotional ties, and the things that come along with the relationship that make it harder to break off a relationship, it's one thing to have a bad first date. It's another thing to end a 25-year marriage. Despite that first date, there's a second and a third. Now, these days are at bars, and there's nothing wrong with that. But, and it just typically ends up, she's going to tell you, I suspect, or you're going to hear that she said, one way or another. It's one thing or the other. Like, I ask a dude for a cigarette, Mr. Torres flips out, and I'm going to pay the price.
So
Things like that. You're going to hear, potentially see.
I don't know how I feel about this argument. I'll just sort of paraphrase since again he's so hard to hear. He's saying that, you know, he's expecting the evidence will show that from their very first date, he, you know, hit Sarah or something, right? And it happened on like the second and third date, I think he also said. And then what he's saying is like, ladies and gentlemen of the jury, like there's a difference between going on a couple dates with somebody versus being married for 25 years. What he's attempting to sort of say is like, if it was, well, my interpretation is like, she didn't have to continue going on dates with him, right? She could have, you know, said, hey, I don't want to see you anymore, because it wasn't like they were in a committed long-term relationship or marriage. But I don't know I don't know. I'm not a huge fan of that argument. I don't think it's really necessary because there's so much evidence in this case against her. You know, because we all know, and probably members of the jury also know that, you know, it's not uncommon for people to have situations where they manipulate you, right? Or like love bomb you and all that. And there's patterns of relationships where, you know, someone might be really cruel, but then, you know, they make it up to you or whatever, or they, you know, say they're going to change. I don't know. I just, this to me is not the strongest argument, but let's see what else how he follows it up here.
Yes, there were injuries that the defendant is going to attribute to the victim causing her. Black eyes, cuts in the face, perhaps from the curtain rod incident that was mentioned in the police interview happening about a month ago. Bloody ear, a stab wound in the leg, which is perhaps described as sword fighting, playing around in that way. But nonetheless, I suspect you're going to hear and see a lot about their past history. And at the end, if this occurs, if this comes in, the state is going to have the opportunity to take the lead of the tour in this room, labeled the defendant and the victim's past history. And I'm not going to go into that now. If this all comes to fruit, the blooms on the tree during the trial, we'll discuss it at the end where it's more appropriate. But I'm asking you to not rush to judgment until you hear all of the evidence in the case. And then apply whether or not these past instances have anything to do with what happened on February 23rd.
And that's where the overact comes in.
Like a home inspector, there are experts to come in and kind of help walk everybody through this room labeled the defendant and the victim's past relationship.
This is a weird analogy.
There's a chance you may hear from some experts.
So he's okay. This is a weird analogy. He's used this and using this analogy of he first started mentioning it earlier when he said something about we're going to come to a door. And it's a door to a room. And he's saying the room is like their past relationship. And then he started segueing into talking about Halloween and vampires. It was hard to hear. And the subtitles, of course, are a mess. So I don't quite know what his point was about the vampires. Maybe he'll mention it again. But it's kind of a weird analogy. Like there's this room and that's their relationship. I don't really know why that analogy is needed. Mind you, this is the same guy who just yesterday when they were having a hearing about what was going to be allowed to come in terms of like the medical records and stuff. There were a number of motions in limine that were discussed. He used that analogy about, he said, let me give you an analogy. You can't just have a dog. And he used this analogy and he started out with a dog, but then used the exact facts of the case, like drinking wine and playing hide and go seek in a suitcase. It was very, very weird. So maybe he needs a little bit of help with his analogies. I don't know. Just my personal opinion.
Things that we would hope that you pay attention to during all the testimony, if there is any, about this subject matter. One is that it's not actually a recognized diagnosis in the Bible.
DSM-V.
Mental health called DSM-V. Diagnostic Statistical Manual, version 5. Text revision, something like that. What it is, and what they describe it as, is kind of a component of post-traumatic stress disorder, PTSD. But because it's not actually in the book, it's like a recipe book. It's like our statute books for lawyers. You go into this book and say you have a particular disorder or diagnosis. It'll say, well, all agree that it needs these 3 elements, like elements of crime. Some of these elements have to be prevalent for a certain amount of time, so on and so forth. You imagine it's a cookbook. Gives you the recipe for a diagnosis. But because it's not in the cookbook, you may get some disagreement about what it means between experts. It's kind of like grandma's recipe handed down.
Another analogy.
But what I expect you'll hear is, it's important for people who don't have experience in certain abusive relationships that are violent to understand the control that can be exerted over an intimate partner by the other one, isolation, psychological violence, emotional violence, physical violence, sexual violence, which I suspect will be described to you as well by the defendant, perpetrated on her by the deceiver. You'll hear about all this. And what it ties into at the end of the day, after we talk about this during jury selection, is if there is a self-defense instruction read to you, this is to help you understand what an objective and reasonable person in the circumstances would do. Because years ago, we've gotten better as a society, but years ago when this was first being researched, the question would be, well, why don't you leave? In battered spouse syndrome, the testimony from the experts help explain those things to people. Well, it's not that easy. You got to look at what's going on in the relationship, isolation, control, so on and so forth. And that explains why you wouldn't leave. Well, now, but turning to the facts of our case, what you're going to decide the facts are is ordinary, objective, reasonable person in those circumstances taking those actions.
Mm-hmm.
That's what it's used for. It's not used for explaining the subjective beliefs that one holds. What you will also hear about these things is, just like any other doctor or any expert, a home inspector. If a home inspector's report was based solely on the person who's trying to sell that house, they say about
Another analogy.
I rewired the entire thing. Brand new JDC pipes. This sucker's good to go. I'm good at this. You're not going to take that home inspector's report unless they lift the hood, kick the tires, do all the things that the box on here, car tax does. You want an expert to get reliable information. The expert's opinion is only as good as the information that he or she relies on. They will say, yeah, you gotta take into account the credibility of the particularly the circumstances that we discussed. Another thing that they're going to tell you is just because there's a bunch of violent nonsense going on between two intimate partners doesn't mean that spouse agreement applies. Some people can go home and fight like cats and dogs. That's just their day, and they get over it. They live their life and find another day. Their cycle spins like that. So just because you hear about those things, what the experts will tell you, doesn't mean that it necessarily applies. If this testimony comes in, I expect that Dr. Harper will say that it applies to this group. But we'll talk to her about what she relied upon to make that conclusion. We'll talk to her about some other things and take that journey together.
I know.
At the end of the day,
It's awful.
after you hear all of the evidence in this case, particularly
I'll check and see if the sound is better on anywhere else, but I think everyone's got the same feed. But I'll double check just in case. I think it's just he's away from the.
statements that you're going to return a guilty verdict for second-degree murder. What the evidence is going to show is that the defendant killed Mr. Torres because she decided he deserved it. Not because the evidence will show an objective, reasonable person in her circumstances needed. Thank you.
He's done.
Thank you, Mr. J.
He's done. Yeah.
Opening remarks by the defense.
By the way, so I did double check the sound. This is the sound everywhere. So yeah. Here we go. That was quick.
The rule. It has
Short and sweet.
I've already advised the witnesses.
Okay, the rule of sequestration will be invoked. Thank you.
You know, if it were me, I would want to know, like if I were Mr. Owens, I would want to know that there's this issue with the microphone so that I could not go away from the microphone. But anyway, that was short but sweet. And now we're on to Mr. Owens. So
You may proceed, sir.
oh boy.
Appreciate y'all being here. I was introduced before. My name is James Owens, and I represent Sarah Boone, along with Tony Peterson and Kevin Depp. Now, this is going to be several days long. Obviously, today,
He said several day trial.
we're not sure, but trying to make
Oh boy.
arrangements for witnesses upon expert witnesses and whatnot, and we'll know more probably end of the day, Monday, so we can plan. But I know your focus is on this case because you took a note. Ladies and gentlemen, there is no higher calling than to write a will.
There's no higher calling. Talking about being a juror.
We're going to ask you to think about this. We find Sarah Boone not guilty because she was justified.
The force that she used was justified. I guarantee is what he's saying there.
That force was
Reasonable.
reasonable.
Yep.
Circumstances
After you.
between Sarah Boone
Thank God.
and George Torres.
Thank God. All right. We got sound.
Sarah Boone and George Torres were down and out.
Yay. They fixed
as
it.
you can be.
They gained the microphone up, I think.
Their life centered around alcohol.
Getting that out of the way.
Both of them suffered from, used to be called alcoholism, now it's called alcohol abuse syndrome. And so day to day, they struggle with the use of alcohol. You can imagine that. It affected their jobs. It affected keeping employment. It affected even getting a job. As codependent as you can be towards each other. And you're going to learn with all that was domestic violence. And that George Torres physically abused Sarah Boone. And she suffered from the effects, the psychological effects that one suffers from repeat violence from an intimate partner. They were together over 3 years.
Interesting. Is he going to try to go along the intimate partner violence route? Like, are we going to have like Depp be heard flashbacks? Can they get Dr. Curry?
There were several prior incidences of violence. We've got the photographs. There were incidences where police were called who took photographs. So you're going to be able to see the evidence. And we believe the court will instruct you at the end when you're considering self-defense, which we call justifiable use of non-deadly force or justifiable use of deadly force, that you can consider the prior acts, the history of violence, the prior difficulties that the parties had, and considering her set of circumstances that she was faced with in making the decision to use reasonable force under the circumstances.
I mean, what it's going to come down to, just briefly, I think in my opinion, is looking at the history, right? Because we know that there were instances in the past where she was also abusing him physically. It's going to look at how bad was it, the abuse that she was dealt, right? And then how does that compare to the night with the suitcase? I mean, it's just going to be, because, you know, that's where the reasonable force comes in, right? Because you can't use more force than what is reasonable and necessary, justified in that situation. So like, even if what I mean is, even if they can establish there was a pattern, blah, blah, if it wasn't like her life was in danger, you know, then her taking someone else's life is not then reasonable or justifiable. It's more force than necessary, you know? So hopefully that makes sense.
And the most important thing I can tell you here today is keep an open mind. There's two sides to every story.
Especially when it comes to
hear the state's side in attempting to paint her a certain way, as they've done here today in opening statement. And then you're going to hear another side. And you're going to have to weigh that. All the evidence, the credibility of the witnesses, the photographs, the videotapes, and come to a conclusion. Now let's talk about this day, February 23rd of 2020, the date of this event. This case has been pending for some time. Here we are, October of 2024.
Interesting that he mentioned
I
that.
think the evidence is going to show that they had purchased some wine the day before, but they hadn't finished all of that. So it was in the refrigerator. Many times that's how they start their day. At some point, you're going to see a video from Publix, from where they live.
I didn't expect wine to be in the lead.
But Publix was not too far from their apartment complex. And they took their car
Morning,
drove
Candace.
over there. So you're going to see a videotape from Publix of them both going in the store about noon, and they come out with one of those larger bottles of
I'm looking forward to seeing that because that has not been released yet. And I'm looking forward to seeing, like, how are they interacting, right? I mean, that's going to be really, because we've not seen, so far we have no image of how they work around each other, right? Like, we have no videos of them as a couple doing anything. So even just to see them going shopping at the Publix is going to be interesting to see the dynamic there. Candace is asking if she has a lawyer. Yes. So what has happened over the past 45 days, what happened is she put out that ad. If you look at the thumbnail that I have there, her actual handwritten ad is in the thumbnail where the tower actually is for the Orange County Courthouse. And she ended up having not just one, but I think there's another attorney and then maybe a paralegal. She's got a team now, and they're all doing this pro bono. And because they heard that she was going to be forced to represent herself, and they thought they can't, because of justice, they can't let that happen. So she's got attorneys. That's what happened. Yeah, whole team. Exactly. Right. I know. And also, for anyone who hasn't heard this, because this just came out yesterday, it was kind of expected that she would take the stand for a number of reasons. But the new part that came out yesterday is it's going to be a narrative defense, like we've seen with Robert Tellis and who else did a narrative defense? There's been a handful of other major cases where they did a narrative defense, but it's going to be a narrative defense for her. And so that's going to be really interesting because she's going to get to just talk and say whatever, you know what I mean? Yeah.
And then, of course, there's a receipt, and the bottles are in the garbage can. Of course, there obviously is an attraction between the two. And as everybody
Shout out to
knows,
Brandon Girl.
couples can have great times.
Still hasn't come up with a
Things
command yet.
Everybody gets along, and then we can have episodes of disagreement. And how are those resolved? Really, is what this is about. How are disagreements resolved? But George was very jealous of Sarah. And you're going to hear the testimony.
Interesting.
About
How?
that. And that he cannot, in certain situations, he can be very charming. But when his level of intoxication gets to a certain level, is when he gets sad, moody, and a lot of times eventually it involved forcible sex with Sarah Boone or actual physical violence against her.
Okay. So she's adding forced sex into the mix, I guess, in her testimony when she talked to us.
It's a simple life. They don't have much money, but they both like art. They did that for a while. They both like puzzles. They did that for a while.
Y'all, whenever they talk about the arts and crafts they're doing, who else here pictures finger painting? Because that's what I picture.
So the wine bottle was gone. And George had said, I want to go get some cigarettes. So there's a convenience store right close by their apartment complex. And Sarah thought he was just going to walk over there and get cigarettes and come back. But no, what he did was he got her keys, he got her debit card, and he went over to the Publix and he got another bottle.
So he's trying to make a distinction here because the state didn't make this distinction. He trying to make the distinction that it was George that went and got another bottle of wine. What the state said was, you'll see there's another receipt. There was another bottle of wine purchased, and they left out who purchased it. And he's saying it was George that went and got another bottle of wine. So that's interesting.
And again, there'll be the
right
video showing
right
going in, going out, and there'll be a receipt.
Yeah, they said at the beginning, they said he was like 103 pounds. Was it either 103 or 104? Abby, if you're still listening, I know it's impossible to hear the prosecutor because they didn't have the mic worked out yet, but I think he said 103 or 104 pounds. So incredible.
Well, when he comes in with the second bottle, Sarah knows this is not good. She knows this means he's going to get to another level of intoxication.
And this is like what I brought up earlier, because another level of intoxication. But the thing is in the past, it wasn't like, there's some relationships where the other level of intoxication and the violence that might ensue is life-threatening, right? But like hitting someone, I mean, it's of course all violence is terrible, but like hitting someone with a curtain rod or, really that's the only example we've heard about from her past abuse with him. It's not like waving a gun around, or I don't know, there's any myriad of examples, but basically, again, you have to weigh it out, right? Is it life-threatening? Is there evidence that she in the past had been subjected to abuse where her life reasonably was in danger in order for her to then justify using that same amount of force? Because it can't be any more force than is reasonable or necessary to stop the threat. And we learned a lot about this too when it came to the Ezra McCandless trial.
So Sarah's concerned. So she attempts to placate him, keep him busy, keep him in a good mood. They drink that bottle, but she drinks as well.
Well,
and at some point, they're intoxicated at a high level. as
She
some
would have
people
done-
do when they're drunk.
She would have done better if she didn't continue drinking. And at least she could say, because she knew there was a threat, she didn't want to get more drunk or whatever. Like, at least that would give her something, right? But she continued drinking. And so then it's the opposite. Now you're less likely to make good decisions.
They get silly. And they decide to play a game of hide and seek.
Hide and seek.
She goes upstairs, their bedroom's upstairs, to the shower and waits for a period of time. And he doesn't come to her.
I know.
At some point, she gets cold, she gets tired. She wants to go see, well, maybe we got it mixed up. Where is he? So she goes downstairs, and they had gotten a suitcase down a week or so ago. It's an old suitcase that they were going to donate to Helping Hands or Goodwill or somebody, and they were putting some items in there. And it's a broken down suitcase.
They would have to take items out to get him in it.
They both weigh about 100 pounds. And they don't eat good. Malnourished.
Well, that's probably not in evidence.
But the pull handle is broken off. And they've attached a little paper clip that's got the rubber around it. And that's how they hold it back and forth. Well, she comes down the steps. She sees him getting in and settling in the suitcase. So she walks over there, and they see each other. They smile and laugh, and she zips him up.
Okay, I just want to clarify something. He says the pull handle. He means the zipper, and that's different. Like when he said pull handle, I'm pictured in a suitcase. I pictured they have those handles on the sides or on the top, or where you can pull it out and then roll it around or whatever. He's talking about the zipper, just so that it's clear, because that's what was broken, and there was this paper clip there as in lieu of a zipper.
And she zips him up, and they laugh for a while. And they carry on. She sits on the couch, and at some point he says, "I can't breathe." Now, his face is facing the zipper, and she's got 2 or 3 inches that she's opened it. And she doesn't know. They're intoxicated. She doesn't know whether he's just saying that to try to get her to get him out or what. But he's a captive audience.
He's a
Physically, they're the same size.
captive
but he's
audience?
much stronger than her. If they got in a fist fight, he would
What?
win 100 times out of 100. But she's got him now. He claims he can't get up. He has to sit and listen.
Okay, captive audience. Okay, so he did say that. All right.
It's a unique form of physical restraint.
What he's getting at here is a captive audience. What he's getting at is that she wanted him to have to sit and listen to her where he couldn't go anywhere. That's what he's getting at here, which is interesting. Because that's actually different than the game. Okay, so I don't know if this is a good argument for him to be making, because it's like if you're saying, okay, well, he got in the suitcase because we were playing hide and seek. But now he's saying she had a captive audience, as in, like, she wanted him to be in a place where he couldn't get away, so he would have to listen to her. 2 different things. And we're going to have issues with this in this trial. Like, this is going to be part of it, right? Because a lot of what she said initially was she was trying to say it was an accident, right? There's so much evidence that at least from her own words, right? It was an accident. It was an accident. It was an accident. So that's why this whole issue of the self-defense / battered spouse syndrome was such a big deal, because that's the opposite. Because that's saying, yes, I did it. It was intentional, but there was a good reason for it. So, and I can tell you the reason why she wanted to go with that strategy, because if she said it was an accident, that she could still be found guilty on a lesser. It's actually a lot like with Casey Anthony. I was talking about this on the last live stream, where you look at the charges, right? If the state has different charges and there's like a lesser included that has anything where it's accidental, right? Or negligent, something like that, right? Then if you come into trial and your strategy was an accident, I didn't mean to do it, then you will be found guilty of that charge. And it might be that it's only a 10-year possible sentence or whatever. But the thing is she wants to be found not guilty and go home, right? So she doesn't. So that's why, That's why she's bringing in this defense of battered spouse self-defense, because there she can't be found liable if the jury finds her not guilty. There's no accident involved, right? In other words, she would be found not guilty of even accidental, manslaughter, because it's an affirmative defense, right? Ezra McCandless, also another one where it's a self-defense case. But the point is that, just like, and again, in Casey Anthony, that's why saying, it's the state could have done better if they had charged with something that was akin to it being an accident. And this same county, by the way, if they had done that, then she could have been found guilty for that, because the whole theory of the case is that it was an accident, right? So anyway, that's why, though, she pivoted. And from what we know, when she went through all these other attorneys, she'd been wanting to do this battered spouse syndrome, and no one else would do it. And that's where a lot of the issues came from what we know, where essentially it's like she wanted to do this and they weren't willing to do it because there wasn't enough evidence to support it. So anyway, I would agree with this 100%, Random Girl. There's no acquittal possible. I would agree with that 100%.
And so she lets him have it. Says things she shouldn't say. You'll see the video. It's about 2 minutes long. She videotapes it. She sits on the couch and turns her phone.
The only way,
for about 2 minutes.
like legally speaking, like the only way that this would work was if, like in the past, he had been threatening her life. Okay. If he'd been putting a gun to her head, or he'd beaten her to where she was in the hospital for an extended period of time, she would have had to have suffered like regularly occurring severe injuries, or have had threats made on her life that someone maybe was a witness to, things of that nature. Again, because this whole point, the amount of force has to be justified. You can't use more force than is necessary to stop the threat. So if you have a reasonable belief that someone's going to kill you, right? The law says that then to stop that threat, it's justified that you kill them to stop the threat. So the fact that she kills him to stop the threat, that's why the medical records are going to matter, and all the police reports matter, because again, all we know so far is that he hit her with that curtain rod, which there's no comparison. That doesn't justify months later taking somebody's life, obviously, right? So that's where the amount of what is the threat and what had happened in the past is what it really comes down to, if there's any teeth to this defense. But from what we know so far, there's not. So
there's another video that's approximately 11 minutes.
and that's why they're going to be relying so much on her testimony, right?
The first video, the suitcase is flipped upside down. The zippers are off. 11 minutes later, Sarah has flipped it right side up. Again, open for him to get out. And it's only 22 seconds. And you hear George say, Sarah. And that's it. Now, the key to the case is that 11 minutes. And what happened during that 11 minutes.
Okay. This is the Overt Act. That's what he's referencing, the Overt Act. So I just want to point out too, because I was just saying, they're going to be relying heavily on her testimony because there's not other evidence to support that she could have had a justifiable fear that her life was in danger, right? Now, typically, when you've got the evidence that's going to come out through the defendant's own testimony, they're being questioned under direct examination by their attorney, right? And the difference here, the reason why it's going to be narrative, this happens when the defendant's attorney here, Mr. Owens, knows that, like, in other words, because of the ABA model ethics rules for attorneys, right? They cannot elicit testimony that they know is false. They can't knowingly elicit testimony that is false. So, in other words, the way that this works is that because he's expecting her to say things that might not be true, all he can do is say, all right, tell your story. And then she can say whatever. And it's not his responsibility, right? He can't lose his bar license over it. So, so whenever, just like we saw again with Robert Tellus, whenever you see that narrative testimony, the jury's not told this, why that's happening, right? But we know it's because more than likely they're saying things that are just not true. And because it's so rare when this happens, right? But it means the attorneys know that there's things that are going to be false. And then from the jury's perspective, it's their job just to judge the credibility based on the witness's testimony. And that's what they're judging, the credibility, right? Because the witness could tell a lie, but they could, if the jury finds the lie credible, then that counts as evidence, right? So my guess, if I had to try to have a crystal ball, is that Sarah Boone, when she takes a stand, is going to try to exaggerate, probably a lot, the whatever happened in the past to try to make it seem like it was her life was in danger, because that's the whole crux of this, right? Whether she adds in more instances than what really happened or exaggerates the severity. And then the question is going to become, just like with Amber Heard, right? Well, why didn't you then go to the hospital? Why is there no medical records of all these injuries? Right? So we'll see how it goes. I don't think it's going to go very well for her, but that's just my personal opinion.
That is the key to this case.
Ah,
Sarah Boone will take
look
the
at that.
stand. She will
Here it is.
explain what happened. She will explain why it happened.
All right, there you go.
The evidence will show that she was justified.
There it is, the
in
justified.
actions she took
Yep.
to prevent an attack from George Torres.
The language of being justified will be in the jury instruction, and that's what's in the stat. Like that's why I keep saying the word justified. It doesn't mean mentally; it means physically, like force. Like if you equate the amounts of force, right, from like a practical level, that's what it means, and that's also why their sizes and weights matter.
Acknowledges that every one of us has a right to invoke the right of self-defense.
And the goal again of self-defense, is to result in an acquittal, because it's an affirmative defense, just like an alibi defense. If you put on an actual alibi defense, it's an affirmative defense. Like I wasn't there, couldn't have been me. They're akin to that in the sense that when you put on an affirmative defense like this, it's, you're looking for an acquittal, but then also it's not burden shifting, but you do have to prove certain elements to go with one of those affirmative defenses. So like there's certain things that they have to show, as has been discussed in these hearings.
You can hear from the medical examiner. She is going to tell you about some bruising on George Torres. Of course, he was in the suitcase a while, deceased, we believe. And that changes things a little bit, as the medical examiner will explain, but there's some bruising. Sarah's going to explain that to you, why that happened, what were the circumstances surrounding that, involving that. Her son comes and stays with him from time to time. He has his own room. He has several of his things there, and there's a bat downstairs. The same bat that George Torres used, and there's a video where George is threatening Sarah, and he's swinging the bat at the TV about as hard as he can. And he does it about 6 or 7 times. You'll see it. Sarah's recording it. And it's during an argument, and he's trying to intimidate. Sarah loved you. You're going to hear why women don't leave. Why women don't leave. And you're going to hear about Sarah Boone and her struggles, her mental health struggles. Sarah had done with him for him. Prosecutor mentioned she wanted him to die. Farthest from the truth. She loved the man. She hated the abuse. She couldn't leave him. She tried. She tried kicking him out 6 or 7 times. He kept coming back. She changed the locks. He kept coming back. She didn't have the family. She didn't have the support. She was weak, vulnerable. You're going to hear it all. You got to take that all into account to try to understand what happened and the circumstances surrounding this tumultuous relationship. Now you're going to find that Sarah's not perfect. And, you know, she goes, as many of us do when we drink too much, you sleep in. She slept in. 11, 12, 1, somewhere around there. She moseys downstairs looking for George. She thought he was on the computer looking for a job. She looked outside, maybe he's out smoking a cigarette, and she sees the suitcase. She unzips it. She gets him out. He's purple. She tries her best to do some CPR. She freaks out. The only family she's got is her ex-husband, really. She relies on him. As the prosecutor said, a lot of times she'll flee to her ex-husband's house. And where her son is at? Lucas. It's the only thing she knows to do. She was kind of a sheltered daughter when she was younger. She's smart, but she's not worldly. She calls Brian. What do I do? He said, I'm coming over. Please come over. He's about 5 minutes away. And she calls him again within a couple of minutes. Yeah, I'm on the way. He gets there. He walks in the foyer and sees his legs. You see, call 911. She calls 911 within a minute, 2. Detective Rodriguez arrives. You know, they got the body cam now, so it's recorded. So you're going to hear Sarah talking. But Sarah's freaking out. Sarah's thinking, and I'm somehow responsible. Eventually, she gives a statement to law enforcement. She gives one to Detective or Deputy Rodriguez. Of course, she's not the homicide investigator. She's just responding. She's the first responder. And, you know, they know what to do. They try to assess the situation. They start putting the tape out, and then they call for the homicide investigators to come, which takes a little time. So she gets a statement from Sarah. Eventually, the homicide detectives get a statement from Sarah and one of the unmarked squad cars, and it's recorded. They hear that. And then the next day, they take Sarah's phone. Sarah gives them the phone, signs the consent to take the phone, take it to, they have a phone extraction people at the sheriff's department where they can take it and take out all the data, all your phone calls, text messages, photographs, videos, all that. And they find these 2 videos. Sarah's not aware. She doesn't remember making the video. You can imagine. She gives him the phone. Well, she makes no attempts to do anything other than, here's the phone. So they tell her, you're going to get your phone back tomorrow. We'll bring it back to you tomorrow. Well, they end up having a conversation with the female detective, homicide detective, Hobson, is her name, Chelsea Hobson. And they end up, Deputy Hobson was pregnant, or Detective Hobson was pregnant. They said, end up, hey, we're not going to bring your phone. I'm not feeling good, pregnant. Can you come to the sheriff's department? Which Sarah Boone was to tell you that was what I was going. That's what they told me I was going to the sheriff's department for. Well, instead, it was an interrogation. And they were going to arrest her. They made their mind up on it. And they were going to confront her and try to get her to confess based on the 2 videotapes. And so there's approximately a 2-hour interrogation that was on the 25th in the afternoon. When she got there to get her phone, they said, well, we got to come up here. We need to talk to you. And they got her in the room. It's a small room, but it's being videotaped and audio taped. And it goes on for about 2 hours of them trying to get a confession to murder. And it doesn't happen. But Sarah lies. She's scared. She can tell they're trying to pin her on this, that this was some kind of intentional act, and it was not. So she lies. She's not a lawyer. She doesn't know about self-defense. She doesn't understand she has a lawful right to defend herself. She doesn't understand that she's justified in using the force that she used.
Okay. So he's trying to explain, this is actually really important. He's trying to explain this discrepancy, that why she was saying it was an accident instead of being honest, quote unquote, about the fact that it was on purpose, that she didn't know that it was just, she didn't understand that the law, basically, is what he's saying.
I wasn't
That's
there
not.
to advise her. No lawyer was there. So she lied. And you're going to hear that. So you're going to have to balance that versus her taking the stand and testifying for you. And we simply ask that you look for the evidence of cooperation of her testimony. It's going to be later, probably next week. The judges will tell you in reading instruction on evaluating a witness's credibility. And they'll talk about corroborative evidence, other evidence that's consistent with the testimony that Sarah Boone did. So you're going to have to weigh that in her testimony. Now, self-defense, we talked about it in jury selection, usually a gun, some deadly weapon. The suitcase in this case was a physical restraint or a blocking of an attack, but it was unconventional.
What? Interesting argument there.
Self-defense, nonetheless. Now, as I said, the struggles that occurred.
That is interesting. I think he's trying to find a way to explain how it was both self-defense and an accident all in one. Basically that, okay, I think what he's trying to say, this is really the only way to make it work. What he's trying to say is that she was putting him in the suitcase. Is supposed to be a shield to block him from punching her or whatever, right? My guess is that then it's the part that him dying is the accident part, right? So in other words, it's that she didn't intend to kill him. She intended to stop the threat by putting him in a suitcase where he's restrained, and then he died because she went to sleep or whatever. That's really the only way to make this work. But I don't know that it's going to be enough, So.
Many of them involve the police. So you're going to actually hear from some of the police officers. Maybe some body cam footage. You're going to see some photographs that they took of the injuries to Sarah Boone. And some of the videos you may see of her in a very happy, joyful type of thing. Well, number one, she's intoxicated. Number two, she's safe. Lisa did. So her attitude is not one of distress.
An unconventional way. That's so wild that he's trying to say that. That's the point of the suitcase. Especially because, well, especially when we know it was about the hide and seek. Like, this is why there's so many issues with this defense, right? Because we know he got into this suitcase for hide and seek, right? And then his next thing was, well, she had a captive audience to where he would have to listen to her. So now it's like, well, now he has to stay put and listen to her. And this is where we need the overt act. And we heard a little bit about this, I think it was yesterday or the day before, about the hand sticking out. And that's the overt act. The overt act would be something he does to then make her think, okay, now there's a threat. And what Mr. Owens is trying to say is that the threat wasn't that she was in danger of being killed. The threat would be that she was in danger of being beaten or hurt, whatever, right? And that in order to stop him, she had to zip it up or whatever. And then he died as an accident as a result. It's strains credulity, I would say, and all of it's going to be really hard to prove. I mean, what it sounds like is looking at the statutes and looking at all the evidence and then trying to figure out a way to explain it, which is reminds me a lot of Esmer McCandless's trial, where the defense had all these creative ways to try to explain certain things, but none of it added up. And it fell flat for them too. So,
We're here today, full packed courtroom. Judge Graydon's here, but you're the most important people, because you've got to decide this case honestly, fairly, and according to the law. And we talked about the two biggest principles from the Constitution that apply. In this case, and in every case in which a citizen like Sarah Boone is brought into a courtroom and accused of a crime. The first is, you as a juror must presume or believe that Sarah is innocent. And that belief stays with you throughout the entire trial. Because of that, she doesn't have to prove anything. That's why the state went first in jury selection. That's why the state went first today. That's why the state will go first putting on their case. They have the burden of proof, and it's the highest burden we recognize in any type of litigation in this country. Proof beyond and to the exclusion of every reasonable doubt. You are going to have doubts about this case.
I don't know about that though, man. I have doubts about the defense.
But the most important thing is not to rush to judgment, to keep an open mind.
I'll tell you what.
And understand there's two sides to this case.
I'll hold that thought.
There's their side and there's our side. So you can't form any fixed opinions early on. That's hard to do, as Mr. Henderson said in jury selection. That's extremely hard to do. Now you're going to hear some testimony. There's been mention of experts. Battered women's experiences affect her perception of imminent danger.
Oh boy. He is in danger.
Battered women's experiences affect her perception of imminent danger. Victims of repeat violence may fear death in a situation others would not.
So here's what the deal. So I was surprised he said that, because basically what happened was, with all these hearings they were having, like yesterday, day before, even up and through this morning, is that he wanted to be able to mention this in his opening statements about battered spouse. Okay. And what was kind of ruled was, like, in terms of the trial itself, like, nothing can come in about this until there's evidence, which it's going to have to come from, like, her testimony. Like, after she testifies, then evidence can be brought in that supports this. But as far as opening statements go, because he's like saying, well, we expect she's going to say this, right? The way it worked, the judge ruled was that he can reference it in opening statements, which he just did. But it's a dangerous game, because if he references it in opening statements and then nothing comes in to support that for the rest of the trial, the state then in closing arguments can hold that against him and be like, yeah, basically you're done. Like you said, it was, you know, so this is risky. This is risky. The other thing I was going to say too about Sarah going to be testifying in a narrative form is with her. I mean, we've all seen what happens when she starts talking, and it's like that sort of thing of like, it's so risky because it's like you're giving someone with her history, kind of like an Alex Murdoch or, you know, other people that just talk and don't keep their mouth shut. You know, it's like giving them, you know, enough length to hang themselves or whatever the saying is, you know, giving them it's like setting up that trap for them, right? By giving them even more room to talk about whatever. So, and again, he doesn't really have a choice because has a reason to believe she might be saying things that are false. So he doesn't have a choice. This is the only option for this defense strategy. Now, if they weren't doing this, if they were going some other route, it would be different because they wouldn't be so reliant on her testimony. But because of this defense strategy with this battered spouse, because they're relying on that and there's not evidence to support it, they're relying on her testimony. And because of the fact that her testimony will be false, they have to rely on her testimony through narrative form. So that's why this is just a hot mess, man. Tell you what.
After hearing both sides of this case, we're confident you're going to have a reasonable doubt. And we're going to ask you to follow the law and do justice in this case. And find Sarah Boone not guilty. Because it's the right thing to do.
The right thing to do. That was a weird.
Thank you, sir.
Okay.
The party's approaching.
There you go. Parties are approaching. So that was a weird way to end that. The right thing to do makes it sound like a moral choice. That's not good. I would have ended with, it's what the law instructs you to do or something like that, right? Like it's just, it's the only possible verdict based on the evidence and based on the law. So while they're doing that, I'm going to go ahead and read real quick. I have pulled up the Florida statute for second-degree murder. Now, here's the thing. Because there is a lesser included. I've been searching. I can't find anywhere what the lesser included is. I wanted to get the exact verbiage of it, but it is something more akin to like an accident or whatever. And again, that's why she's not going that route with her defense. But here's the second-degree murder in Florida. So second-degree murder is defined as the unlawful killing of a human being when perpetrated by an act imminently dangerous to another and evincing a depraved mind regardless of human life. That's like basically saying disregard for human life. Although without any premeditated design to affect the death of any individual. So basically in Florida, the difference between first and second-degree murder is simply the premeditation. And that's not the case in every state, right? In some states, the premeditation isn't the key thing, it's the intent. And that can be formed in an instant, as we always hear. Okay.
State, you may call your first witness.
All right.
State will call Juan Torres.
Oh, wow. So here's my plan, guys, going forward. Okay, so this is going to be George's brother or one of his brothers. So here's my plan going forward. So my plan going forward is this. Well, that's not a good place to have it paused because we're just being suit. All right. So my plan going forward is this, is that what I'm planning to do is for the rest of this trial, which looks like it's not going to be all that long, I'm going to be doing like recaps, you know? And then when it comes to key witnesses, like maybe like Brian Boone, and obviously when Sarah takes the stand, I'll cover that testimony fully. Now, depending on when it is, it may or may not be live as it's happening. I'll do just like with Karen Reed, right? If I can do it, I will. Otherwise, I'll cover it in full, you know, that same evening or whatever. But that was kind of what from what I'd heard from you guys in the chat and on the Discord and stuff like that, that was kind of what people were saying is that, you know, I think because A, there's a lot of coverage of it, but B, I am doing right now currently the Casey Anthony trial, gavel to gavel, and I'm still keeping up with all the Koberger stuff too. But from what people had voiced to me was that they kind of voted for more of a recap situation when it came to this trial. But the exceptions that I wanted to make would be for like opening statements, Sarah Boone, closing arguments, and then probably like, again, I think Brian Boone's testimony will be really important. So that, but other than that, it'll be just sort of like, kind of recaps of the key highlights or whatever. So anyway, that's all that. So there should already be a playlist now formed for this trial. And shout out to Iowa's Backyard Cam. Oh. I don't even know about that shooting. Is that a school shooting? That's terrible. So, yeah, just, you'll hear me mention that the audio was not very good up until they started with the defense, and then they got it kind of worked out. So yeah, so I was concurring that recaps are good. Cool. So, and it's like, I'd be willing to do it, but I know it's a lot for everyone who wants to try to keep up with things. And again, because I know there's a lot of places that are covering this trial, gavel to gavel. So, I think it's especially important too, like, again, like there's a difference between say this and like say Casey Anthony, where like no one had ever watched a gavel to gavel that I've found. So it's necessary, I think, for us to go through a gavel to gavel, and then for it to be the first time on the internet where there's a gavel to gavel with any type of like commentary or analysis or whatever. So that's definitely necessary to do it justice. But yeah, so here we will kind of hit the high points and whatnot. But y'all, I appreciate everybody being here. I'm still finishing timestamps for the live stream from yesterday. Was it yesterday? Day before? Casey Anthony, and I'm close to being finished, but the vast majority of it does have timestamps already. And I'll be getting a highlights video out soon here as well for that episode. And then the next episode for that series, I believe I have scheduled for tomorrow. So for anyone who is new, if you're watching, or on replay crew, if you're new, make sure you subscribe and turn on the notifications. And, if you're interested in joining the Discord, there's notifications in there as well, so that you can see what's going on. And I do have playlists for all the trials that I've covered at this point. There's actually quite a few. So each trial has its own playlist. So you can also keep up with things there. And Nightbot just put the link for the Discord in the chat. So thanks everybody again for watching. Thanks for being a squirrel, and I'll see y'all next time.